Good afternoon. My name is Christopher and my colleague Bas will present to you the topic of this video, which is the formation of the contracts in different member states of the European Union. We'll present to you also the main features of the common and civil law legal system.
Offer and acceptance are required in all member states of the EU. However, some of the member states recognize the additional feature such as consideration in common law, which is an exchange of promises in which for both parties there is a benefit and a burden to the agreement. This means that the consideration must concern something with value for the law. Civil member states like Germany and France and the Netherlands do not know this concept of consideration, and an offer and acceptance is sufficient for the establishment of a contract. For France, causa is added to these two criteria. Within the CESL, the European Commission made clear in Article 30, subsection 2, that in their view offer and acceptance is sufficient to establish a contract.
However, offer not always means the same in all the member states of the European Union. While in the common law, the advertisement in a newspaper is an offer, but in France that would be merely invitation to treat. Principles of European contract law basically reflects the view of the common law countries, and the offer may be made to one or more specific persons or to public.
The next issue we would like to address is the acceptance. The main issue there is if the contract will be legally binding from the moment one party dispatches its acceptance or from the moment the party who made the offer receives the acceptance. Within the common law system, there is a legally binding agreement where the acceptance has been dispatched, while in the civil law member states, the receipt theory prevails. Within the CESL, the Commission chose to follow the receipt theory, as demonstrated in Article 35, subsection 1 thereof.
The next legal issue we would like to address is intention to be bound by the contract and the revocation. So, in all the member states of the European Union, if it appears that the parties were intended to be bound by the contract, they are actually legally bound by the contract. The same view is reflected in the principles of European contract law, which states that any form of statement or conduct by the offeree is an acceptance if it indicates assent to the offer. The other issue is revocation. Can an offer be revoked? In common law countries this is indeed possible before acceptance has been dispatched. But for instance, in Germany this is not the case and the person cannot revoke the offer. In the CESL, revocation is possible before the person who would have accepted has sent an acceptance, or, in case of acceptance by conduct, the contract has been concluded according to Article 32.1 of the CESL.
As we have seen, there are differences between the member states in the formation of a contract. There is the area of consideration, offer, acceptance and revocation. We also have something in common, however, and that is the intention to be bound.
In the next week, we'll focus on finding a compromise between all the parties involved in the negotiations. Thank you very much for being here.